You pull out your smartphone, you type a complex prompt into an artificial intelligence model, and you expect the power to just be there.
Right. It feels instantaneous.
It feels completely invisible. But trace that invisible power back to its actual source, and suddenly you are not standing in a pristine, climate-controlled server farm.
No, definitely not. You are hundreds of feet underground.
Exactly, surrounded by massive, highly complex machinery, in a space where the air is thick with dust and the physical labor is just intense. I mean, it is the absolute collision of the modern digital age and brute physical reality.
Yeah, that's a great way to put it.
And making sense of that collision is exactly what we are doing today. But before we jump into the bedrock of this issue, please take a second to like and subscribe to the show so you never miss an analysis.
So today we are looking at the House Committee on Education and Workforce field hearing.
Right, the one titled Protecting Workers and Powering America, The Future of Mining. This took place on May 8th, 2026 in Fort Branch, Indiana.
And our mission is to unpack the key debates, the financial impacts, and, well, the future implications discussed at this hearing.
We are drawing directly from the official transcript and the written testimonies from 4 key witnesses.
Yes, witnesses representing industry operations, legal compliance, and worker advocacy.
Okay, let's unpack this. So we start with the core motivation for the hearing, which is why are these officials and experts gathered in Indiana right now?
It really comes down to a massive collision of supply and demand. We are currently seeing an unprecedented surge in energy demand across the country.
Driven by the rapid expansion of artificial intelligence, right?
AI, the construction of massive new data centers, and the reshoring of foreign manufacturing back to the United States, they all need power.
And it is crucial to understand how AI data centers consume power. I mean, they do not just use electricity, they require what is called baseload power.
Right, baseload power.
AI data centers do not care if the wind stops blowing or a cloud covers the sun. They require a massive, uninterrupted fire hose of electricity. And currently, only traditional resources like coal or nuclear can provide that unblinking 24 hours a day reliability.
Exactly. What's fascinating here is the tension between advancing technology, like AI, and its reliance on traditional resources like coal. Because while that tech demand is skyrocketing, the domestic supply side, specifically coal, has plummeted.
The statistics they presented at the hearing regarding the local region were pretty staggering.
Yeah, they were. In 2014, Indiana produced a record 39.1 million tons of coal. That was across 27 mines.
Okay.
But just 11 years later, in 2025, that production fell by more than 50%. It went down to 18.4 million tons across just 9 mines.
And the geographic footprint shrank from 13 counties down to just 6. What fascinates me is the immediate human and financial impact of that decline. The testimony noted that coal miners earn an average of over $90,000 annually.
Which is significantly higher than other rural sectors like agriculture or general manufacturing.
Right. Think of a massive coal mine like the anchor tenant in a large shopping mall.
Okay, I follow you.
If you remove that main department store, the food court and the smaller boutiques lose their foot traffic and they eventually collapse. It is the exact same ecosystem here.
It really is. The hearing revealed that for every one mining job, there are at least 3 indirect jobs providing goods and services.
We are talking about heavy equipment repair, rail transportation, material supply.
Right, and when a mine closes, that massive payroll just vanishes from the local economy. The rural tax base craters.
Meaning less funding for local infrastructure.
Exactly. School enrollments decline because families have to move away to find work. And those who stay are often forced to take lower-paying jobs just to remain in their hometowns.
Okay, but hold on, let me stop you there. If these coal plants and tech companies are desperate for baseload power, and the jobs pay nearly 6 figures with strong benefits, the math just does not seem to add up.
It's a paradox for sure.
Yeah. Why did the testimony indicate these massive operations are struggling to find people?
That is the paradox at the center of the workforce debate. One of the general managers for a major energy company testified about a massive perception gap.
A perception gap.
Yeah. People still picture mining as a 19th century endeavor. They imagine workers using picks and shovels in the dark.
Right, covered in soot.
Exactly. But the reality is that modern mining is highly technical. Operators are running automated, specialized equipment using screens and joysticks. The industry currently requires mechanical, civil, electrical, and software engineers to function.
But I have to push back on this traditional narrative of a labor shortage. Reading through the testimony, if these jobs are actually high-tech software and engineering roles and they pay near six figures, is the industry truly suffering from a labor shortage? Or is it just suffering from a terrible public relations problem?
That is a highly accurate assessment.
I mean, if high school students do not know a software engineering job exists at a coal mine, they certainly are not going to apply for it.
Right. The testimony revealed it is largely an awareness and training gap. Local educational systems are simply not funneling students toward these roles.
Right, they mentioned Gibson County.
Yeah, in Gibson County, it was pointed out that schools tend to steer graduates toward other regional employers, like the local Toyota plant. There is no clear, well-promoted pathway for high school graduates to navigate into the mining trades.
So how is the government attempting to build that pathway? Because clearly something has to bridge that gap.
The committee discussed both legislative and executive actions. Chairman Wahlberg highlighted House Resolution 8210.
That's a Stronger Workforce for America Act of 2026, right?
Yes, exactly. This legislation aims to reauthorize the Workforce Innovation and Opportunity Act to better align training programs with actual employer needs.
And the hearing also covered executive action, specifically President Trump's Executive Order 140-278 from April 2025.
Right. And as a reminder, we are just impartially reporting the facts regarding these administrative actions purely as they were argued by the witnesses.
Of course. So that order directs federal resources toward creating 1 million new active apprentices to prepare Americans for skilled trade jobs, explicitly including the mining sector.
And the execution of those training programs happens at facilities like the Vincennes University location.
Which actually hosted this field hearing.
Yes, they serve as the missing link between a high school graduate and a highly technical career. They train 3,000 miners a year using modern simulators in a mock underground mine.
So they get hands-on experience.
Exactly, giving workers experience with the automated tech before they ever step foot in a real operation.
All right, so you bridge the awareness gap, you train the workers on the high-tech simulators, and you get them down into the mine. But once they are down there, running the place becomes a severe regulatory maze.
Oh, absolutely. The operations side of this is where the friction really escalates.
It seems like it. The debate over how the Mine Safety and Health Administration, or MSHA, regulates these operators was a central focus.
A compliance attorney outlined why MSHA is so much more burdensome than the Occupational Safety and Health Administration, known as OSHA, which regulates general industry.
I want to break down exactly how different those two agencies operate because the mechanisms are completely different.
They are. Under the Federal Mine Act, MSHA possesses warrantless inspection authority. They mandate regular, comprehensive inspections.
How often are we talking?
Surface mines are inspected twice a year, and underground mines are inspected 4 times a year. But most significantly, mine operators face strict liability.
Strict liability.
Yes. This means they are legally liable for any violation on their site, regardless of fault, knowledge, or the degree of the hazard.
Let's contrast that with a regular warehouse under OSHA. In a warehouse, if an employee sneaks a forbidden tool into the building and gets hurt, the employer might successfully argue they took all reasonable steps to prevent it.
Right, they can defend themselves.
But in a mine under MSHA, the operator is liable the second the violation exists, period.
Precisely. The attorneys at the hearing argued that this entirely punitive system lacks the performance-based incentives found in general industry.
So what was their proposed solution?
They advocated for a statutory change to create a pattern of compliance designation. This would function similarly to OSHA's Voluntary Protection Program. It would reward operators who demonstrate a strong, documented history of safety with regulatory relief, rather than solely punishing the bad actors.
Here's where it gets really interesting. Because the current rigid framework actually creates unintended consequences that penalize safety. Wait, let me make sure I have this straight based on the testimony. They put in extra expensive safety cables that the government didn't even ask for, and if one of those cables gets a scratch, they get a permanent mark on their record.
Yes, that is the exact scenario provided in the testimony. Operators are voluntarily buying shielded electrical cables for mobile underground equipment.
And these are not legally required.
Not required at all, and they are significantly more expensive. But operators buy them because the internal shielding provides an extra layer of protection against electrical shock.
It is like a student doing a voluntary extra credit project. They put in the extra work, they make a minor typo on that extra assignment, and the teacher fails them for the entire class. Why would any mine operator ever go above and beyond if the system punishes them for it?
They often don't, because of how MSHA writes the citation. If an inspector finds minor damage to the outer jacket of that non-required cable, they issue a citation. Furthermore, they frequently attach a significant and substantial, or S&S designation to it.
And that goes on their permanent record.
Yes, that S&S designation goes directly on the mine's permanent compliance record. This legal liability actively discourages operators from investing in advanced voluntary safety measures.
Add to that the struggle operators face with vaguely defined regulations. The testimony highlighted a specific rule requiring operators to notify MSHA within 15 minutes if there is an injury which has a reasonable potential to cause death.
Right, the 15-minute rule.
But MSHA has never clearly defined what reasonable potential actually means. In the chaotic, adrenaline-filled moments following an accident, mine managers are forced to guess whether an injury meets that vague standard.
And if they guess wrong?
If they guess wrong and miss the 15-minute window, they face severe financial penalties.
So the operators are arguing for regulatory flexibility and clarity. But, we have to look at the other side of this equation. Worker advocates at the hearing presented a very different set of immediate concerns.
Right, because while the financial and regulatory debates happen above ground in conference rooms, miners are facing urgent physical risks below ground.
The testimony regarding the health crisis was stark. One of the attorneys who represents coal miners detailed what is happening in depleted mineral basins in places like Appalachia and the Illinois Basin.
Which includes Indiana.
Exactly. This comes down to the geological reality of mining today. The easily accessible, thick seams of coal were mined decades ago. To get to the remaining thinner seams, operators are now having to cut through massive amounts of surrounding sandstone.
And we need to explain why cutting sandstone is so much more dangerous than cutting traditional coal. When you cut sandstone, it releases respirable crystalline silica dust.
Which is incredibly toxic.
Yeah, these are microscopic particles, almost like tiny shards of glass. When a miner inhales them, the immune system attacks the particles, which causes severe scarring in the lung tissue.
And that scarring is irreversible, right?
Completely irreversible, and it destroys the lung's ability to process oxygen.
The worker advocates describe the current situation as a slow-moving hawk's nest disaster. That references the tragedy in the 1930s where hundreds of rock drillers died of acute silicosis.
It's terrifying.
The hearing noted that today, miners as young as 28, with only 10 years of experience, are showing severe lung function loss. There are documented cases of miners in their 30s and 40s requiring double lung transplants simply to survive.
To address this specific health hazard, the Biden-Harris administration issued a respirable crystalline silica rule in 2024. The goal was to establish a breathable dust limit for miners that is comparable to the protections that already exist for other American workers in general industry.
However, the testimony detailed that following industry lawsuits against the rule, MSHA did not defend the regulation in court. This effectively set the rule aside.
And just to reiterate, we are simply reporting the events as presented in the hearing.
Yes. During the hearing, committee members and witnesses discussed these recent regulatory actions alongside the Trump administration's earlier deregulation orders to provide historical context on the agency's shifting priorities over the last several years.
Alongside the setting aside of the silica rule, the worker advocates highlighted a massive systemic breakdown in safety oversight, driven heavily by recent budget cuts.
It is a severe breakdown. The administration laid off 1/3 of the staff at the Mine Safety and Health Review Commission.
1/3 of the staff.
Yes. That left only 3 administrative law judges nationwide to handle all enforcement actions and appeals. By August of 2026, the commission is projected to lack a quorum entirely.
Meaning what?
Which will completely halt all their official business.
Wow. And that oversight deficit at the judicial level is compounded by an operational failure at the inspection level. A newly released Office of Inspector General report was introduced at the hearing.
Right, the OIG report.
The report found that MSHA failed to document accident investigations for 97% of the incidents that legally qualified for scrutiny.
97%.
Think about your own workplace for a second. Imagine a piece of heavy machinery fails. Someone gets severely injured, and the federal safety agency tasked with protecting you only bothers to investigate 3 out of every 100 severe accidents.
It's hard to fathom.
That is the reality these workers are stepping into to power the devices we are all using right now.
This raises an important question. How can the United States rapidly expand its mining infrastructure to meet the massive energy demands of the AI and manufacturing boom, while the basic health and safety oversight infrastructure is critically understaffed, backlogged, and failing to investigate 97% of qualifying accidents.
That is the multi-billion-dollar question. If the oversight is already failing on traditional operations, what happens when we introduce entirely new extraction methods?
Right, because that leads us right into the final major topic of the hearing, which is future markets and emerging technologies.
The federal government is pouring massive amounts of money into modernizing extraction. The Department of Energy recently announced nearly $100 million in funding under an initiative called the Mine of the Future.
And of that money, $80 million is earmarked specifically for developing and commercializing advanced mining technology.
The focus of this massive federal investment is rapidly shifting away from traditional coal and toward rare earth minerals. We are talking about materials like lithium and cobalt.
These are crucial right now.
They are the foundational elements required for modern batteries, electric vehicles, and high-tech defense systems.
But extracting these rare earth minerals requires completely new methods. One method discussed heavily at the hearing is called in situ leaching.
And we need to explain how this works because it is fundamentally different from traditional mining. Instead of digging rock out of the ground with heavy machinery, they are pumping chemical solvents directly down into the earth.
Right into the bedrock.
Exactly. These chemicals dissolve the minerals right where they sit. Then they pump that chemical soup back up to the surface for processing.
It was described in the testimony as being somewhat similar to the mechanics of hydraulic fracturing, or fracking. And you can immediately see why worker advocates are raising alarms.
Because of the chemicals involved?
Yeah, the long-term health risks of these new chemical extraction methods, particularly regarding groundwater contamination and worker exposure to the solvents, are largely unknown.
Witnesses forcefully called for MSHA and the National Institute for Occupational Safety and Health to conduct immediate, rigorous scientific studies on in situ leaching.
Right, NOSH needs to get involved.
The goal is to lay the groundwork for safe, scientifically backed regulations before these new chemical-heavy extraction methods become widespread across the country.
What's fascinating here is, well, it's the tension between the push for green technology and the physical reality of acquiring the materials for it. We're trying to build a clean energy future using extraction methods that currently lack comprehensive safety data.
So, what does this all mean? It means the smartphone in your pocket, the AI models we use daily, and the batteries powering the shift toward green energy are inextricably linked to unresolved safety questions.
They absolutely are.
The technology of tomorrow is still fundamentally tethered to the physical labor, the dust, and the hazardous environments of today.
As for the immediate next steps following this field hearing, the official committee record remains open for 14 days.
That's to allow for additional statements, right?
Yes, to allow for additional written statements and extraneous materials to be submitted by the public and industry experts. More pressingly, though, the Workforce Protection Subcommittee announced they will hold another hearing next week.
And that upcoming hearing is going to be critical. It will specifically address the emergency safety issues raised by the worker advocates, and it will demand answers regarding that alarming Office of Inspector General report.
Right, the one detailing MSHA's 97% failure rate in documenting accident investigations.
It is a rapidly evolving situation that sits right at the intersection of energy policy, labor rights, and technological advancement.
It really is.
As we rush to mine the rare earth minerals required to power our high-tech future, are we simply trading the old, highly visible respiratory hazards of the 20th century for new, unstudied chemical hazards of the 21st century? It is a question the industry and the regulators have not yet answered.
Thank you for joining us as we analyze this vital issue. You flip a switch, the lights come on, but the invisible power driving our world is anything but simple.